Sir, the service entrance is in the back.
I have a 2 o'clock with your general counsel. I'm not holding a toolbox.
You sure you're in the right building?
I'm a partner, and I'm late because you assuming I'm something else.
For 12 years, Amanda Winters sat behind the reception desk at Hartwell Industries headquarters in downtown Minneapolis. The 50-story glass tower housed one of the Midwest's largest pharmaceutical companies, and Winters controlled who walked through those lobby doors: executives, clients, vendors. She'd been there long enough to know the building's rhythms, the patterns of who belonged and who didn't. At least, that's what she thought. What she didn't know, or maybe didn't care to know, was that 47 people had complained about her over those 12 years. 47 incidents of Black attorneys being questioned, Latino consultants being redirected, Asian executives being told the service entrance was elsewhere. Not because they'd done anything wrong, because Winters looked at brown skin and expensive suits and couldn't imagine those people had legitimate business on the executive floors. Management dismissed every complaint as security protocol. Her supervisor praised her attentiveness. Building leadership called her cautious. Nobody called her racist, even though that's exactly what she was. Wednesday afternoon, downtown Minneapolis. Everything Winters had gotten away with for over a decade was about to catch up with her. Tariq Holloway, 42, walked into that lobby in a charcoal suit with a leather briefcase. 16 years as a corporate attorney. 8 of those as partner at Morrison & Rhodes, one of the Twin Cities' most prestigious firms. He'd built a career specializing in pharmaceutical contracts and regulatory work. Minnesota Lawyer magazine had featured him as a top attorney under 45. He'd negotiated deals worth hundreds of millions. That day, he was there for his 5th meeting with Hartwell's general counsel to close a $200 million licensing agreement. Winters saw him and made the same assumption she'd made 47 times before. Black man in the lobby must be there to fix something, deliver something. Certainly not negotiate something worth 9 figures. That assumption, that automatic judgment based on nothing but skin color, was about to cost her everything. Her job, her reputation, and it would cost Hartwell Industries $15 million in a settlement that would expose exactly how corporate bias operates in marble lobbies, where everyone thinks they're too professional for racism. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Downtown Minneapolis. Hartwell Industries Tower rose 50 stories above Nicollet Mall, a glass and steel structure where pharmaceutical executives develop drugs and manage global operations. The lobby was marble and chrome, designed to impress clients and project corporate power. The reception desk controlled access, sign-in sheets, ID verification, visitor badges. Amanda Winters sat behind that desk like a gatekeeper deciding who belonged. Tariq Holloway had grown up in North Minneapolis, in a neighborhood where opportunity was scarce and expectations were low. His mother was a nurse who worked double shifts at Hennepin County Medical Center, coming home exhausted but always checking his homework. His father drove trucks for UPS, leaving before dawn and returning after dark, but never missing his son's basketball games or debate competitions. They'd worked those demanding jobs for 30 years to send Tariq and his 2 sisters to college, sacrificing vacations and new cars to build a college fund. Tariq had been the first in his extended family to attend law school. He'd excelled at Macalester College on a full academic scholarship, graduating summa cum laude with a degree in political science. Then he earned a full ride to University of Minnesota Law School, where he served on law review and graduated in the top 5% of his class. His professors recognized his talent immediately. His legal writing was precise and persuasive. His oral arguments were commanding. His understanding of complex regulatory frameworks was exceptional. He'd clerked for a federal judge in the 8th Circuit Court of Appeals, a prestigious position that opened doors throughout the legal profession. The judge, a white woman who'd broken her own barriers, mentored Tariq and connected him with opportunities. He joined Morrison & Rhodes as an associate at 27, one of only 4 Black attorneys in a firm of 87 lawyers. He'd worked 100-hour weeks to prove himself, taking every assignment, volunteering for the difficult cases, building a reputation for excellence. He'd made partner at 34, the youngest partner in the firm's 80-year history, and one of only 3 Black partners. The achievement made the legal press. His parents attended the partnership celebration, his mother crying with pride, his father shaking hands with senior partners who praised Tariq's work ethic and brilliance. It was a moment of validation, years of sacrifice paying off. His specialty in pharmaceutical law made him invaluable. Clients paid his firm $850 per hour because his work was exceptional. Wednesday at 1:52 p.m., Tariq had a 2 o'clock meeting with Margaret Chen, Hartwell's general counsel, to finalize a licensing deal between Hartwell and a Boston biotech startup called Neurobridge. The agreement was enormously complex, involving intellectual property rights, manufacturing licenses, distribution territories, and regulatory approval pathways across multiple countries. The deal structure had taken 4 months to negotiate, patent attorneys from 3 firms had weighed in, regulatory consultants had analyzed FDA requirements, international experts had examined European and Asian market access issues. Neurobridge had developed a breakthrough drug for treating Alzheimer's disease, but they lacked the infrastructure and capital to bring it to market globally. Hartwell had the manufacturing facilities, distribution networks, and regulatory expertise to commercialize the drug worldwide. The licensing agreement would grant Hartwell exclusive manufacturing and distribution rights in exchange for $200 million upfront plus royalties that could reach into billions if the drug succeeded in clinical trials and gained FDA approval. Tariq had structured the entire deal. He'd negotiated every clause, anticipated every potential dispute, and created frameworks for resolving disagreements without litigation. His work was meticulous. Both sides trusted him to find solutions that protected their interests while allowing the deal to close. Today was the culmination of months of work. Both CEOs would be in the room, the contracts were ready. Missing this meeting would jeopardize everything. Tariq arrived 8 minutes early, professional, prepared. He'd been to this building 4 times before for earlier negotiation sessions. Same procedure every time. Walk in, sign in, show ID, get badge, wait for escort, simple. He walked through the revolving doors carrying his briefcase with the final contract inside. He approached the reception desk where Amanda Winters sat. He'd never seen her before. Different shifts meant different receptionists. Before Tariq could speak, before he could give his name, Winters looked up and made her assumption. "Excuse me, sir. The service entrance is around back." Tariq stopped. "I'm not here for service. I have a 2 o'clock appointment." Winters' skepticism showed immediately. "An appointment? With which department?" "Legal. I'm meeting with the general counsel about a contract negotiation." "The general counsel?" Winters' tone made clear she found this impossible. "Are you sure you have the right building?" Tariq glanced at his watch. 1:54. "I'm sure. I've been here 4 times already. My firm represents your company." If you check your visitor log, you'll see Tariq Holloway from Morrison & Rhodes scheduled for 2 o'clock with Margaret Chen. Winters didn't check the log. She stared at Tariq, trying to reconcile what she saw with what she expected. "Your firm? What exactly do you do?" The question hung there, not confirming his appointment, questioning whether someone who looked like Tariq could be an attorney. Tariq felt anger rise but kept it controlled. "I'm an attorney, partner at Morrison & Rhodes, and I'm now 10 minutes late because you assumed I was maintenance. Do you think corporate receptionists should face consequences for racially profiling business visitors? Drop your answer below." Winters flushed. "I didn't assume anything. I was just directing you to the correct entrance." "The correct entrance for what? For black people? I'm wearing a suit. I have a briefcase. I told you I have an appointment with your general counsel, but you told me to use the service entrance." "Why?" A voice came from behind. "Mr. Holloway?" An executive assistant appeared from the elevators, a woman in her 50s named Susan who'd escorted Tariq before. "I'm so sorry. Margaret asked me to meet you. Have you been waiting long?" "No, but I've been told to use the service entrance while your receptionist questioned whether I actually have an appointment." Susan's face went from professional to shocked. "What?" She looked at Winters. "Mr. Holloway is one of our outside counsel. He's been here multiple times. Why would you send him to the service entrance?" "I thought," Winters stammered. "He didn't look like..." "Like what?" Susan's voice was cold. "Like an attorney? He's wearing a suit. He told you he had an appointment with Margaret Chen. What didn't look right?" The lobby went quiet. Other visitors watched. Everyone understood what was happening. Winters couldn't articulate her reasoning. Susan's professionalism cracked into genuine anger. "Print his badge. Mr. Holloway is late for an important meeting because of this." Winters' hand shook as she clicked her mouse. The screen showed what she should have checked immediately. Tariq Holloway, Morrison & Rhodes, 2 p.m. Margaret Chen, executive access. Everything exactly as Tariq said. "I'll need your supervisor's name," Tariq said quietly, "and I'll speak with HR before I leave. This isn't acceptable." Susan nodded. "Absolutely. Please come with me." The elevator ride was silent. Susan texted rapidly, alerting Margaret Chen. When the doors opened on the 48th floor, Margaret was waiting. She was a brilliant Chinese-American attorney who'd risen to general counsel through merit. She looked at Tariq's face and knew something had gone wrong. "Tariq, what happened?" Your receptionist told me to use the service entrance, questioned whether I had an appointment with you, refused to check her log, asked what I do, implying I couldn't be an attorney. 15 minutes wasted. Margaret went from concerned to furious. Susan texted me. I thought she misunderstood, but this actually happened in front of witnesses. And Margaret, if this isn't addressed properly, Morrison and Rhodes will reconsider representing Hartwell. The threat was real. Morrison and Rhodes brought significant revenue, but no money was worth subjecting partners to profiling. Margaret understood this wasn't about hurt feelings. This was about whether Hartwell could work with diverse professionals. Come to my office. We'll close the deal, then I'm calling HR immediately. The meeting happened. The deal closed. $200 million. Contract signed. Champagne opened. The startup CEO thanked Tariq for brilliant work. Hartwell CEO praised the deal. Everyone celebrated except Tariq. He just closed one of his career's biggest deals, but victory felt hollow after being treated like a trespasser. After the clients left, the HR director met Tariq in a conference room. Tariq repeated everything. The service entrance comment before he'd stated his business, the credential questioning, the log refusal, the visible skepticism, the assumption he couldn't be an attorney. The HR director took notes. Mr. Holloway, we take this seriously. We have lobby security footage. We'll review it and take appropriate action. Appropriate action meaning what? A warning? Training? Because if this gets buried like other complaints, my firm walks. This won't be buried, I promise. Tariq left at 4:37, 3 hours after arriving. He'd closed a major deal worth $200 million. His firm would earn over $1 million in fees. His client was thrilled. His work had been exceptional, but he felt exhausted, humiliated, and angry. The professional triumph was overshadowed by the racial humiliation that had preceded it. He sat in his car in the parking garage for 10 minutes, hands gripping the steering wheel, breathing slowly, trying to calm the rage coursing through him. He thought about all the times this had happened throughout his career, the assumptions, the questioning, the disbelief that he could be an attorney, the exhaustion of constantly proving he belonged in spaces his credentials had earned him access to. He thought about his parents, who'd worked so hard to give him opportunities, and how they'd feel knowing their son, a partner at a prestigious firm, had been told to use the service entrance at a client's building. He thought about the younger black attorneys at his firm, the associates who looked up to him as proof that success was possible. What would they think if they knew even partners got profiled? Would it discourage them? Would they wonder if the struggle ever ended? He thought about his wife, who heard these stories regularly and carried her own experiences of being a black professional in predominantly white spaces. The cumulative weight of these incidents never fully disappeared. Each new one added to the burden. That evening, he called his managing partner. Robert Morrison listened without interrupting. "That's completely unacceptable," Robert finally said. "Let's see how they handle it. If they bury this, we drop them. I don't care about the revenue." The investigation moved fast. Margaret Chin demanded priority. The HR director understood the stakes. They pulled lobby footage, high-definition video with audio. It showed everything. Tariq approaching professionally. Winters' immediate dismissal. The service entrance comment within seconds. The credential questioning. The log refusal. All documented. But the HR director went further. He pulled footage from the past year. He analyzed every visitor interaction at Winters' desk. He looked for racial disparities. He found them immediately. Over 12 months, Winters had redirected 47 visitors to service entrances or questioned their legitimacy despite scheduled appointments. 43 were people of color. 4 were white. When cross-referenced with appointment logs, 38 had pre-scheduled meetings with Hartwell executives. They were invited guests treated as suspicious based solely on appearance. The HR director contacted some of those 47. Many provided statements. An Asian IT consultant described being sent to the vendor entrance despite meeting the CIO. A Latina marketing executive was asked repeatedly what she was fixing. A black Goldman Sachs analyst was questioned so extensively his client came down to vouch for him. The pattern was undeniable. Winters had systematically profiled visitors of color for years. 47 complaints filed, all dismissed. No one had analyzed the data. No one had looked for patterns. Should corporations conduct monthly audits of reception interactions to identify discrimination before reaching 47 incidents? Let me know what you think. Amanda Winters was terminated within 1 week. The termination letter was direct. Miss Winters engaged in discriminatory behavior toward visitors based on race over 12 years. Security footage and logs confirmed systematic redirection of people of color to service entrances despite appointments. questioning credentials with skepticism not applied to white visitors and creating hostile experiences for clients and professionals. Her actions violated company policy, anti-discrimination laws, damaged reputation, and jeopardized business relationships worth millions. Employment terminated immediately. Ineligible for rehire. Winters tried fighting it. Her attorney argued security caution, but video destroyed that defense. Footage showed her waving white visitors through while interrogating people of color, checking logs for some but not others. Disparate treatment so obvious even Hartwell's lawyers admitted the case was indefensible. Tariq wasn't satisfied with just termination. He wanted systemic change. He met Hartwell's CEO personally. Your lobby is client's first impression. When that impression is profiling, it poisons everything. Your receptionist told me to use the service entrance before I gave my name. She saw a black man and assumed I was fixing something. How many relationships were damaged? How many talented people decided not to work with Hartwell after being humiliated? The CEO listened, pale. Mr. Holloway, you're right. This is unacceptable. We're implementing immediate reforms. Within 30 days, reforms were in place. All reception staff required bias training annually. Written protocols requiring appointment verification before assumptions. Mystery shopper program using diverse testers quarterly. Direct hotline for discriminatory treatment reports. Monthly statistical analysis of redirections and verifications with immediate investigation of disparities. Requirement to ask visitors' name and appointment before suggesting entrances. But Tariq still filed suit. He tracked down other Winters victims. 23 joined as plaintiffs, all professionals of color, all with appointments, all humiliated. An architect designing Hartwell's facility, a McKinsey consultant, a Chicago patent attorney, a pharmaceutical scientist interviewing for senior position. Each with stories of being questioned, redirected, treated with suspicion while white professionals sailed through. The lawsuit named Hartwell for negligent supervision, creating hostile environments for business visitors of color and failing to address documented discrimination despite 47 complaints. Damages were compensatory for humiliation and professional reputation damage, plus punitive to send a message. Hartwell's attorneys gave honest assessment. Video was damning, pattern undeniable. Company ignored 47 complaints. Plaintiff group included highly credentialed professionals whose testimony would be compelling. Trial would be disastrous. Recommendation: settle quickly and generously. The case settled in 8 months. $15 million divided among 24 plaintiffs. Tariq received $2.5 million. Others got $400,000 to $1 million each, depending on severity and professional impact. Settlement required maintaining reforms 5 years with annual third-party audits. Morrison and Rhodes debated dropping Hartwell despite settlement. The diversity committee argued representing a company that tolerated such discrimination sent wrong messages. But reforms were substantial, apology genuine. Margaret Chin personally committed to prevention. The firm voted to continue but on probation. Any similar problems would end the relationship immediately. The story became a corporate training case study, not because of violence, but because it showed how bias operates professionally, how assumptions made in seconds shape interactions, how front desk staff undermine diversity initiatives executives publicly support, how discrimination patterns persist without data analysis. Tariq spoke at the Minnesota Bar Association conference. Standing before 500 attorneys, he told his story publicly. I'm a partner at a prestigious firm. I wear $1,000 suits. I carry a briefcase with my firm's name embossed in gold. I speak with law school vocabulary. I close deals worth hundreds of millions. But none of that mattered to Hartwell's receptionist. She saw my skin and decided I was fixing something, not negotiating something. That assumption happened before I spoke, before I gave my name. It was instantaneous and entirely racial. He paused, surveying the mostly white audience. If this happens to me with all my credentials, imagine what happens to black delivery drivers, Latino maintenance workers, Asian food service staff entering corporate buildings. How are they treated? With suspicion, hostility? How many can fight back? The room was silent. This isn't one racist receptionist. Winters didn't act in a vacuum. She profiled 47 people over 12 years, 47 complaints filed, all 47 dismissed. That's not one person's prejudice. That's institutional failure. That's valuing a receptionist's biases over the dignity of invited guests and business partners. The speech circulated widely. HR departments used it in training. Law firms examined their practices. Corporations audited reception areas. The case forced uncomfortable reckoning with bias in supposedly professional spaces. Morrison and Rhodes audited their own reception. They discovered subtle disparities. Nothing as egregious as Hartwell, but enough for corrective training. They implemented new protocols and feedback. They acknowledged if it happened at a client's office, it could happen at their own. For Tariq, settlement brought justice but didn't erase damage. He avoided visiting client offices when possible. He insisted on meetings at his firm, on his turf. When he had to visit elsewhere, he'd call ahead, ensure someone met him in the lobby, avoid reception desk interaction. The hypervigilance exhausted him and never fully disappeared. 18 months later, Tariq was invited back to Hartwell to speak about diversity efforts. In the same building where he'd been humiliated, he addressed 200 employees. Some of you were here that day. Some heard the exchange. Did anyone think about intervening? Did anyone consider your receptionist was wrong? Or did you assume she had a reason? He looked around. That's how bias works. It affects the profiler, the profiled, and everyone who witnesses it and does nothing. When you see unfair treatment and stay silent, you're complicit. You signal this behavior is acceptable. His voice softened. Winters lost her job. That's accountability. I received substantial settlement. That's compensation. But what really changes culture is what happens next. Culture changes when everyone here decides profiling isn't acceptable, even when it seems minor, even when it's just suggesting wrong entrances, even when it's questions that seem innocent but carry assumptions. Culture changes when you speak up. Standing ovation. Several employees apologized for not intervening. One marketing manager said she'd felt uncomfortable but didn't know what to do. I'm sorry. I should have said something. I won't make that mistake again. Hartwell's reforms became industry models. Mystery shoppers were particularly effective. Diverse testers visited quarterly, documenting experiences. Disparities triggered immediate retraining or termination. Statistical analysis caught problems before reaching dozens of incidents. The reforms worked. But 2 years after the incident, Tariq experienced it again. Different city, different client, Chicago corporate lobby. Before he could speak, the receptionist asked, "Are you here for a delivery?" Tariq felt exhaustion wash over him. The anger, the deja vu, the realization that no matter his success, someone would see skin before credentials. He breathed, controlled his voice. "No, I'm an attorney. 2 o'clock appointment. Check your log." She checked immediately, apologized quickly, gave his badge, but damage was done. Assumption made. Again, Tariq closed his deal brilliantly, but driving to his hotel, he called his wife. "I'm tired, so tired. Every new client means proving I'm not the help. Every lobby is a test. I'm a partner. I've closed billions in deals collectively, but I still get asked if I'm making a delivery." His wife said what she always said, "You're not just doing this for yourself. Young black attorneys see you succeeding, see you fighting back, see you refusing to accept this. That matters." "It does," Tariq agreed, "but I wish it didn't have to." The real question is, what changes now? Do corporations finally audit reception desks before lawsuits force them? Do they train staff to verify appointments before assumptions? Do they understand diversity initiatives ring hollow when visitors of color are sent to service entrances? Because if we don't fix systems that allowed Winters to profile 47 visitors over 12 years without consequence, if we don't address assumptions teaching reception staff to see black people in suits as workers, not executives, if we don't create accountability before patterns reach dozens of victims, then we're just waiting for the next lobby, the next receptionist, the next attorney, told they don't belong where they're being paid for expertise. Winters lost her job. That's consequence. 24 plaintiffs received $15 million. That's partial justice. But settlements don't erase humiliation of being told to use service entrances. They don't prevent the next reception desk from harboring same bias. They don't change that. Successful black professionals still must prove they belong in spaces where white professionals are automatically assumed to fit. Tariq still practices law, still closes major deals, still represents pharmaceutical companies and biotechs. But he carries the weight of knowing his next client meeting might start with someone assuming he's there to fix something rather than negotiate something. That vigilance never fully disappears. That's the tax successful black professionals pay daily. Comment below if you think reception staff showing racial profiling patterns should face immediate termination after 3 incidents, not 47. And if you believe stories like this need to be told, if you think accountability matters and corporate lobbies can't be gatekeepers based on bias, then hit that subscribe button. Because we're going to keep exposing these patterns. We're going to keep demanding companies fire staff who humiliate professional visitors before anyone notices the pattern. We're going to keep fighting for a world where a law firm partner can walk into a client's building without being told to go around back. This isn't just about Amanda Winters or Tariq Holloway. It's about all of us, and whether we're willing to acknowledge that bias operates in marble lobbies with expensive art just as much as it operates on city streets.